Yeah, so I had to do a muted at start at some point. Good evening. Thank you for joining us. So, when you listen to people who lived through Watergate, one of the things they tell you is that there was a time when basically there was new news every single day, and this was before the internet, and it was literally just new revelations every day, and it was just startling. This is what we have now is, if you've been following from the beginning, this is huge. If you're just joining us and have no idea what's really been going on, the nuance of what's been going on with Trump, this may not mean a whole heck of a lot. We're going to break it down, but I suspect at this point it's going to be a long week. It looks like the government has had about all they're going to take of Trump, and I think this is the beginning of the end, is my take on what we're seeing now. We have two pieces of news to bring to you. The first is a leak that happened to answer Michael Westby's question. It appears to be a leak. We don't actually know if it was a deliberate release or a leak. It's still too early. It's about a little more than 3 hours old at this point, but it was the full text of a letter that the National Archives sent to Donald Trump. Now, we just did a breaking news not that long ago on Trump's defense to these documents, and he's going to be asserting executive privilege in part while at the beginning of his defense in a what appears to be a pro se case that he is, or a pro se litigation. He is challenging the Justice Department in their obtaining of these documents, and he's saying that essentially that without a special master to review every single document, they all have to be assumed to be privileged. He is saying that he hasn't broken any laws, he's cooperated fully, and that the attack, in his words, from a swarm of FBI agents was unnecessary since he was fully cooperating. Less than 3 hours after we became aware that that was going to be his defense, and after he filed that motion for a request for a special master, this was released. The timing is, I don't think, accidental, and as I said, I think this is a good indication that the government has had about all they're going to take of Trump. This letter is actually, that I can tell, obliterates absolutely everything that Trump is arguing. We don't, when we're covering breaking news, like to go into these things in detail. Unfortunately, we have to. This is, fortunately, it's a reasonably short letter, but every sentence matters in this case. We had asked, if you watched our show of just 3 hours ago, we had said there were a couple of questions that you needed to answer before you could say definitively one way or the other in regards to several issues on Trump's defense. Those questions appear now to have been answered. So since it all dovetails, we decided we would go live with this. And like I said, I think you can expect we're going to be doing more of this. The full content of this letter we are going to display here as we scroll through it. You can also find it on our Discord, as you can find the sources for basically all of the information that we go through here. You can find all of our sources, and you can even participate if you so choose and volunteer. We appreciate all the help. You can also become a channel member. A lot of people work very hard for this show. It's 2 a.m. Eastern Standard Time, and we are bringing you this because we think it's that important. This is staggering, and the fact that we have this is a very good indication that the government is done, and Merrick Garland is not playing, and not remotely. So, having said that, the first piece of news that we wanted to cover, it's reasonably brief, but the Justice Department has issued a new grand jury subpoena to the National Archives, which is going to feature heavily in today's, in this particular breaking news segment. This is all about the National Archives. The Justice Department has already issued one subpoena for records in regards to January 6th. They've now issued a second subpoena for a set of documents. And what we're going to learn now is that they actually already were clamoring to get at the documents that were first taken from Trump's Mar-a-Lago resort, residence, whatever it is. And I think we're going to start because this is a lot that needs to be unpacked here. This was sent to Evan Coran Silverman Thompson. Evan Coran Silverman. I don't feel like I'm getting that correct. I'm going to say Mr. Coran, a Baltimore, Maryland attorney who we believe at this point was representing Trump. So, let's start. Dear Mr. Coran. All right. This is going to be one of I'm going to have to concentrate on this one because my reading's already really, oh, dear Lord. And this was sent again by the National Archives, which is essentially the organization responsible for all of this material. It was obtained. It was the FBI that went and snagged it, but it was, watcher. This is going to get worse than compartmentalized. This is going to get worse. So this is sent by the National Archives. So everything we're going to discuss for the next few minutes is going to be entirely from the view of the National Archives. That's important for reasons we just discussed in our last show. Dear Mr. Kokorin, I write in response to your letter of April 29th, 2022 and May 1st, 2022, requesting that the National Archives and Records Administration, that's going to be referred to NARA, I'm just going to say the National Archives to keep things reasonably simple, but when you hear NARA going forward, that's the National Archives. They're responsible for holding these documents. This letter actually beautifully explains exactly what the problem is. Requesting that the National Archives further delay the disclosure to the Federal Bureau of Investigation the records that were subject of our April 12th, 2022 notification to an authorized representative of former President Trump. What they're actually talking about here, I believe, is the first 15 documents that were taken from Trump's residence. So we are now about to get into that very first 15 set, which was one of the things we mentioned. That was already classified material. He had already taken it almost certainly illegally. We've discussed that, and this just cannot be made clear enough because there's the right-wing media is saying he can declassify these documents. Yes, the Supreme Court has determined that he can that all classification stems from the executive branch and stems from the president or people that he's empowered for classification and declassification, with the exception of anything that is legislated specifically as an exception. We've talked about this several times. We've shown the actual, we've given the Supreme Court case that determined this. If it is a statutory exception, the president cannot, under any circumstances, declassify it. All nuclear documents are a statutory exception. None of those documents he had the power to declassify that, notwithstanding a whole bunch of other issues. So that discussion's over. At any rate, as you are no doubt aware, the National Archives had an ongoing communications with the former president's representatives through 2021 about what appeared to be missing presidential records. So we know that they knew, he says, throughout 2021. So they knew for some time before they got the original 15 documents. The 15 boxes of documents, they knew. So they knew he had them. Which resulted in the transfer of 15 boxes of records to the National Archives in January of 2022. So that's the first transfer that we're talking about, where he said, see, I complied. In its initial review of the material within those boxes, the National Archives identified items marked as classified national security information up to the level of top secret and including sensitive compartmentalized information. That's the SCI that we've discussed before. Those are documents that cannot be taken out of a specific room that is designed just to see those documents. The room there's no radio waves that can go through the room. Viewing equipment won't work in the room. The room is designed. These documents are so critical to the national security of the United States, they cannot be removed from this room, and he had them at Mar-a-Lago. And so this confirms that in the original set, which is one of the questions we had asked about, we presumed that the original set of 15 sets of documents were, in fact, similar to what's been pulled now, top secret SCI. They were also special access program materials, which I know almost nothing about. This is the first time we've actually heard of this, but it seems to me that this is at a minimum a similar level of classification as TSSCI, which is the top secret sensitive compartmentalized information. So this is another. Yes, there were SCI docs in the first 15. So this is another level of classification now, presumably at least as high as SCI. Now, the National Archives informed the Justice Department of what was in those records, as they obviously would be required to by law. They are confirming here that that is, in fact, what they did. So the legal process has actually already been started, and the Justice Department was aware of it. And what we have here is this is a response. Now, when was this? This is of May 10th again. I want to remind people this is not current. This is May 10th. This was just leaked about 3 hours ago. But essentially what he is saying here is that they had known for some time that he had documents, that there was every level of classification was in the first 15 set that they had taken out, and that they had been trying to get them from him. And it's suggesting here he had not been cooperating. But once they got them, they informed the Justice Department that they had them. And he, as of this point, had been attempting to get them to not notify the Justice Department. This would probably be where the interfering with an investigation charge comes in. At least it's going to start with this. It's going to continue. Up to level of... Okay. The National Archives informed the Department of Justice about the discovery, which prompted the department to ask the president to request... ask the president. Earlier, Trump had been referred to himself as the president. It is actually... in some cases considered appropriate to refer to a former president as Mr. President. It's an older form. It's not done as much anymore, but you can refer to non-sitting presidents, former presidents, as Mr. President. It's obvious Trump's going to refer to himself in this way. It's not normally done, and one reason is because of the confusion it creates here. At this point, when they say the president, they're referring to Biden. This is a huge problem because this means Biden's been aware of these missing documents, and he has the ability to classify any documents that he wants to. So even if Trump had been able to declassify them, they've all been reclassified by Biden as of that moment. There is no way that Biden did not say, okay, these are just reestablish and certify the classification. So again, there is zero. All of these Trump's got zero defense on the classification grounds. All right. Asked the president to request the archives provide to the FBI with access to the boxes at issue so the FBI and other intelligence communities could examine them. On April 11th, the White House counsel's office affirming a request from the Department of Justice supported by an FBI letterhead memorandum formally transmitted a request to the National Archives that provided the FBI access to the 15 boxes for its review within 7 days. So the original 15 boxes were supposed to be turned over to the FBI and other intelligence organizations within 7 days. And with the possibility that the FBI may request copies of specific documents following its review. Although the Presidential Records Act generally restricts access to presidential records in the National Archives custody for several years after the conclusion of a presidential tenure in office, the statute further provides that, quote, subject to any rights, defenses, or privileges which the United States or any agency or person may invoke. This is going to become important. Such records shall be made available to an incumbent president if such records contain information that is needed for the conduct of the current business of an incumbent president's office and is not otherwise available. So, the current president can override the executive privilege of a former president if it is necessary for that president to do his job of office and if he needs those records. Now, this is similar, but not quite the case that had been talked about earlier where, well, gee, could Biden revoke Trump's claim of executive privilege? And there was a lot of hooey about all of that. This is slightly different. The reason this is different is because this has nothing to do with a legal case. This has nothing to do with any third-party issues. This has to do with a current sitting president having the right to have documents of the previous administration, since they belong to this country, if he needs them in order to do his job. This is from 44 U.S. Code Section 2205. These conditions are satisfied here. This means that the National Archives agreed that these documents were of vital interest to the sitting president, and Trump was not allowed to invoke executive privilege. This is important because that means the National Archives now this has not been adjudicated by a judge, but the National Archives concurs and cites case law saying that executive privilege cannot apply to any of these documents, whether they're classified top secret or not. Doesn't matter, so long as they're necessary to the current administration, which most of these documents necessarily must be. All right. So that means his defense that he offered just 8 hours ago is not tenable. Assuming this is accurate, and I have to believe it is, it's coming from the National Archives. These are important national security interests in the FBI and other intelligence community getting access to these materials. According to the National Archives, among the materials in the boxes are over 100 documents with classification markings comprising of more than 700 pages. So the original 15 boxes had 700 pages of classified material all the way up through compartmentalized. We have now learned that there was at least 300 pages of material that were taken out of Mar-a-Lago in the most recent FBI raid. All told, that is over 1,000 pages of documents classified from I think the lowest level of classification, which if I recall is confidential, all the way up through top secret compartmentalized. That's 1,000 pages of these documents. Some include the highest level of classification, including special access program materials. All of these are documents that have to be read into, and Trump had probably was not authorized. I don't even know. I can't fathom he was authorized to have some of these documents because there's no reason to read him. This is unprecedented. This is utterly insane. I think people want to know how he got some of these things. We do know that for presidential daily briefings and a few other, when he was receiving classified briefings, the reports were he was having difficulty reading the material. So he would ask to have it explained to him, and then he would keep the documents and take them back with him to the residency, which was prohibited. It's illegal. He's not allowed to do that. It appears at some point they started to let him do that. Nobody kept track of what happened to the documents, and he kept them. Access to the materials not only necessary for the purposes of our ongoing and criminal investigation. All right, so the criminal investigation had already started before the FBI raid. This, again, is May 10th. But the executive branch must also conduct an assessment of the potential damage resulting from the apparent manner in which these materials were stored and transported and take any necessary remedial steps. Accordingly, we are seeking immediate access to these materials so as to facilitate the necessary assessments to be conducted within the executive branch. Okay, to be clear, what they're asking for is for Trump to stop blocking them from handing over the original 15 boxes to the FBI because in their assessment, he is not permitted to do so. And in their assessment, the FBI needs these documents in order to see if any laws were broken, and that at this point, he appears to be obstructing a criminal investigation. We advised you in writing on April 12th that, quote, in light of the urgency of this request, we plan to provide access to the FBI next week. Again, this is to the original 15 documents. The week of April 18th, see executive order. And okay, so it looks like, and this stems from an executive order. So that also means that Biden, which you'd kind of expect, but this is our first confirmation, that Biden knows exactly what's going on and how long it's been going on 4. Biden requested these documents. It came from his office. These documents are necessary for his office in order to conduct the business of the sitting president, and apparently Trump was blocking their access to it. All right. The archivist may at any time may adjust any time period or deadline under in response to a request from another representative of the former president, the White House counsel's office acquiesced in an extension of the production date to April 29th. So again, Trump attempted to block the FBI access to the original 15 documents, which is their criminal investigation of what these documents are and how he obtained them. The White House counsel's office said that an extension could be provided because Trump was fighting it and advised the National Archives. In accordance with that agreement, we have not yet provided the FBI with access to the records when we had received your letter, and we have continued to refrain from providing access, such access to date. So what that means is, as of April 10th of this year, while they had recovered those 15 documents, all of them at various levels, 15 sets of documents that were classified as either had some level of classification all the way up through top secret. The FBI still did not have access to those files because Trump was fighting them, and they kept having delays. And the National Archives at this point is asking Trump to withdraw his objections, finding them groundless and saying that they cannot, he can't sustain them. So apparently Trump had a April 29th letter. He asked for additional time to review the material in order to ascertain whether any document was subject to privilege. And then, let's see, he may make a decision as to the claim of the constitutionality based on that privilege. Your April 29th letter further states that in the event we do not afford you such time to review the records before the National Archives discloses them to the FBI, we should consider your letter to be a protective assertion of executive privilege made by counsel of the former president. So he is now, the defense that he is now using for the current set of documents, including the 11 we now believe 300 pages of top secret documents taken out. He's actually already asserted this claim on the previous 15 boxes of documents. So this is them confirming that he has asserted that claim previously. The counsel to the president has informed me that in light of the particular circumstances presented here, President Biden defers to my determination in the consultation with the Assistant Attorney General for the Office of the Legal Counsel regarding whether or not I should uphold the former president's purported protective assertion of privilege. Accordingly, I have consulted with the Assistant Attorney General for the Office of Legal Counsel to inform my determination as to whether or not to honor the former president's claim of privilege or instead to disclose the presidential records notwithstanding the claim of privilege. The Assistant Attorney General has advised me that there is no precedent for an assertion of executive privilege by a former president against an incumbent president. So again, these documents belong not to Trump, but to the United States of America, and are classified or declassified, except where in statute, by the President of the United States, who has requested the documents back, and Donald Trump has refused. That is what this letter of May 10th is saying. So to reiterate that one again, because I think that's an important paragraph. Accordingly, I have consulted with the Assistant Attorney General to inform, the Assistant Attorney General has advised me that there is no precedent for the exertion of executive privilege by a former president against an incumbent president to prevent the latter from obtaining National Archives presidential records belonging to the federal government, where such records contain information that is needed for the conduct of business of the incumbent president's office and that is not otherwise available. Biden's administration requested these documents, not the FBI, not the Justice Department. It was the office of the President of the United States requested these documents, and Trump attempted to withhold these documents from the FBI on the grounds of executive privilege. This is with the first 15 sets of documents. To the contrary, the Supreme Court's decision in Nixon versus that because you want to be the guy on the receiving end of a Nixon decision. Nixon administration versus the Administrator of General Services strongly suggests that the former president may not successfully assert executive privilege against the very executive branch in whose name the privilege is invoked. In Nixon versus the Administrator of the General Services, the court rejected the former President Nixon's argument that a statute requiring the presidential records from his term in office be maintained in the custody of and screened by the National Archives' predecessor agency, a, quote, very limited intrusion by personnel in the executive branch sensitive to executive concerns would, quote, impermissibly interfere with a candid communication of views by presidential advisors. What this means in common English is that the reason we have executive privilege, and it's extremely important, and I fully support the concept of executive privilege. The reason is because if the president thinks that anything that he just banties about through brainstorming, or if any of his advisors think that anything that they banty about through brainstorming can just be released to the public, they are going to withhold good advice because they care about how it's going to be perceived outside the office. Therefore, executive privilege means that certain advice that's given to the president, whether it's on paper, whether it's by phone, is privileged and cannot be released without the president's assent. However, according to the Supreme Court decisions here, that is subject to any number of exceptions, including when said documents are needed by the current administration. So it appears as if, at least in the view of the National Archives and actually by the Assistant Attorney General with whom they consulted, executive privilege already has been determined by the U.S. Supreme Court to not apply in the terms in which Donald Trump has previously applied it to the 15 documents, and just 8 hours ago, a little less, tried to apply it to the recent set of documents, which we just covered around that time. Let's see. Let's see. So that's the exception. See, emphasizing rejecting non-powers challenge. Within the executive branch, employees would have access to the materials. Okay, so the other part of this exception is so long as it's not being used for anything other than for lawful government use. That makes sense. So they would still try to protect the privilege, but the documents would still exist within and operate within the executive branch. The quote, the executive branch remains in full control of the presidential materials, and the act facially is designed to ensure that the materials can be released only when the release is not barred by some applicable privilege inherent in that branch, concluding that nothing contained in this act renders it unduly disruptive to the executive branch. In other words, making this exception to executive privilege would not undermine executive privilege so much so as to undermine the essential reason for that privilege. It is not necessary that I decide whether there might be any circumstance in which a former president could successfully assert a claim of executive privilege to prevent an executive branch agency from having access to presidential records for the performance of valid executive functions. The question in this case is not a close one. The executive branch here is seeking access to records belonging to and in the custody of the federal government itself, not only in order to investigate whether those records were handled in an unlawful manner, but also, as the National Security Division explained, to conduct an assessment of the potential damage resulting from the apparent manner in which these materials were stored and transported, and take any necessary remedial steps. These reviews will be conducted by the current governmental personnel who, like the archival offices in the Nixon v. GSA, are, quote, sensitive to executive concerns. And on the other side of the balance, there's no reason to believe any such reviews could, quote, adversely affect the ability of future presidents to obtain candid advice necessary for the effective decision-making. So again, why do we have executive privilege? So that presidents can get honest advice without people fearing that what they say could be used against them in some way. That's why there's executive privilege, and it's already been determined in the previous Nixon case that this kind of circumstance would not negatively impact the ability and purpose of executive privilege. To the contrary, ensuring that classified information is appropriately protected and taking any necessary remedial action if it was not are steps essential to preserving the ability of future presidents to, quote, receive the full and frank submissions of facts and opinions upon which effective discharge of their duties depend. In other words, if the government can't keep classified documents classified, executive privilege is dead anyway. Because an assertion of executive privilege against the incumbent president under these circumstances would not be viable, it follows that there is no basis for the former president to make a quote, protective assertion of executive privilege, which the Assistant Attorney General informs me has never been made outside the context of a congressional demand for information from the executive branch. In other words, leaving the executive branch, going from one branch to another. This is all internal. The information already belongs to the executive branch. Even assuming for the sake of argument that a former president may, under some circumstances, make such a protective assertion of executive privilege, to preclude the archivist from complying with a disclosure otherwise prescribed by 44 U.S. Code 2205, Section 2205, there is no predicate for such a protective assertion here, where there is no realistic basis that the requested delay would result in a viable assertion of executive privilege against the incumbent president that would prevent disclosure of records for the purpose of the review described above. Accordingly, the only end which would be served by upholding the protective assertion here would be to delay those important reviews. So what he's saying is, essentially, if I understand this correctly, the government's going to get those documents no matter what. All at this point that Trump's assertion is doing would be to be delaying, which he apparently had done successfully up until this point, delaying the FBI's getting of the original 15 boxes, which it seems is roughly similar to the 11 that were taken out in the previous raid. I therefore decided not to honor the former president's protective claim of privilege. There are several executive orders here, which would there be orders from the president. We also know that it appears that the president did order the National Archives to hand over these documents. The archives appears, from, if I'm reading this correctly, they appears to have stopped in lieu of a request from the White House counsel's office based on Trump's assertion of executive privilege. They kicked that back to the National Archives saying, you decide if you believe executive privilege applies here. My suspicion is that Biden himself made that decision, and he made it so that it was impartial, because the reality, as impartial as can be, because the reality is Trump and Biden are political adversaries, and they both ran for president. So Biden kicked it up to the head of the archives and National Archives, and they said, yeah, this is a joke. The way I read this is very politely, this is a fucking joke. Fuck off. Politely, but that's what they're saying. I have concluded there is no reason to grant your request for further delay before the FBI and others in the intelligence community. That would be NSA. Begin their reviews. Accordingly, the NRA will provide the FBI access to the records in question as requested by the incumbent president, beginning as early as Thursday, May 12th. So this letter was sent the day before the FBI and probably the NSA was handed all of the documents that had been obtained in January. So these documents were taken out of Mar-a-Lago in January. 15 cases of classified material that I can tell there's no grounds to make the maximum charity I can give. There are no grounds to say he had these legally. We've discussed this repeatedly. He cannot have declassified them. The number of NSA violations that he has here is staggering. NSA, National Security Act. Is it the National? I'm too tired. I don't care anymore. At any rate, He had been delaying them and successfully had it delayed until the 12th when the Records Administration said, no, we're done. And he had asserted executive privilege, which apparently had succeeded in delaying this to some extent. That is what he just several hours ago did with the previous documents. It looks like there's already a framework for denying this, so I think he's going to be in trouble. At any rate, this tells us a number of things that we did not already know. This tells us that what we had suspected and what we had kind of hoped for, if you're looking for this to be understood by our federal agencies, which I'd kind of like them to get to the bottom of this, the previous documents were, in fact, top secret, and they have been turned over to the FBI. The FBI and, quote, other intelligence agencies. That at a minimum includes the NSA. If it was the CIA, they'd probably say it. If it's the NSA, they don't say it. The NSA stands for the National Security Administration. The joke is it stands for no such agency. They don't talk about it. The first rule of the NSA is there is no NSA. At any rate, there's no such agency. So we know now that they have been treating this very seriously for a good deal longer than we had thought. It looks like since they said throughout 2001, they've been trying to get these documents back from him. We know that they got 15 boxes back. This strongly suggests, especially since we know that there was some kind of informant who said that the other boxes were there. We know that he did not comply. He ostensibly was told to return all of it. All of it would just by a matter of course have been reclassified by Biden, just in case, just to cover all the bases. But the fact is, Trump cannot have declassified them anyway. So this is a leak, I guess. I don't know how this got out, but this also suggests that there's his defense has already been tried and failed. I think what I said at the top of the hour with this. It looks like there's no agency in the government that's playing around with this anymore. This was released by somebody in the National Archives. Probably it could have been one of his lawyers. His lawyers are probably jumping ship. He has to represent himself in this latest action because he's pro se. And we have this on our Discord too. If you want to join our Discord, go through the breaking news. But we've been covering. Nobody wants to represent him. A, they don't get paid. B, he asked them to break the law, and they could all lose their license. Giuliani's already done. And C, he's the most impossible client to work for because he, quote, knows better, and he never follows anyone's advice. So this goes all the way to the current president of the United States, which you'd think it would, but frankly, all the rules, in my view, have been out there. I mean, I wouldn't have been surprised if, especially considering that the DoJ really turns out didn't know very much about what the January 6th committee was doing. They got pissed and they're like, well, wait, you guys haven't told us any of this stuff. So it's felt like the government has been playing catch up. This letter suggests that while maybe on January 6th they have, when it comes to Trump, they've been taking this very seriously. At this point, having seen more than my fair share of criminal cases, I have no idea how. I mean, F. Lee Bailey, I talk about F. Lee Bailey. When people say, well, my lawyer's won 100% of his cases, run from that lawyer. Run from that lawyer. The only lawyer who's ever won 100% of his cases are the ones who only take the easy ones, won't take the hard ones. If you take the truly hard ones, you're going to lose sometimes. F. Lee Bailey lost 55% of the cases he tried. 55%. He's considered one of the best lawyers in American history. Why? Because the ones he did win, nobody could win. Nobody could win. And he won them. He took the hardest cases there. I have no idea. Yeah, this is, wow. Okay. At any rate, this is important because it tells us a whole bunch of new things. One, they've been on this for a while. Two, they were trying to get the documents from him at least sometime in 2001, presumably pretty early. That completely destroys his defense of having cooperated. We now know he has not been cooperating. We have just seen an email from the National Archives, and we've all kind of suspected he wasn't cooperating. There's no reason for this to have gone down this way unless he wasn't cooperating. We now know he wasn't. We know Biden has been involved. We know Biden is aware of this, and we know Biden ordered the National Archives to turn this over to the FBI so they could investigate it and probably to the NSA, and that was delayed by Trump as he was asserting executive privilege, and that failed. He has now, just today, attempted to exert the exact same executive privilege over the 11 boxes. Now it is going to go before a judge, but based on what I've seen, I think he's going to have a problem there. So, elephant in the room, Melania is the leak. Yeah, that would be something. Wouldn't surprise me. It's her get out of jail free card. Yeah. So anyways, this email is staggering for any number of reasons. First of all, the fact that it got leaked. The government's done, I think. I think from now on, any defense that Trump asserts. Now, one of my concerns is we had to go over the document, and I'm hoping if you've listened to it this far, you understand how and why. This is a reasonably complex document. It's reasonable legalese. It's a little dry, but it tells us a tremendous amount that we didn't know, or confirms things that we had already deduced, but couldn't say for a fact. It tells us that this has been going on for some time. It tells us that they've known these documents were there, and it tells us that they've all, the first set was, and this is also the confirmation of the final piece that we were looking for, which is, and I said this tongue in cheek. Look, I know for a fact, he got all of these documents, the first set and the second set, when he left the White House. There's no way to have gotten them any other way. But the reality is, in a court of law, you still have to demonstrate that. This demonstrates that. It demonstrates that he's been withholding all of the documents and they've known it. It demonstrates that he has not been cooperating. It's pretty surprising. So, and it demonstrates that the government's no longer gonna respect the confidentiality of emails if Trump is going to play games. So I think as of tonight, it's a full court press, and they're not playing with him anymore. It's going to be a long week, folks. It's going to be a long week. At any rate, thank you all for joining us. We do apologize. I know that was a bit of a slog. I think it's worth it. I think it's worth understanding exactly what that says and what that tells us. I have little doubt in my mind most of the nuance and what's in there and what's important in there is going to be ignored by most of the right, who are going to go back to, well, confidentiality, executive privilege, and he's been cooperating. The fact that on May 11th, I think it was May 10th or May 11th, they had to send him this letter, and the contents of this letter demonstrates all of that's untrue. All of that's untrue. So that's where we are. Thank you very much for joining us. We're going to keep an eye on it. Best place to find it is our Discord. That's where usually this information gets dropped first. We collate it. We make a decision as to whether or not to go live. Thank you to the mods. Thank you to Titan and everybody else who at nearly 3 a.m. in the morning is covering this. But I think this is it, folks. This is that Watergate moment. The dam has broken. The dam has broken. We've been wondering when the dam is going to break. This email is proof that the dam is broken. The National Archives isn't playing anymore either. They're like, look, we told you this. The only reason to release this email, the only reason to release this is because of his filing earlier today. We're going to see a lot more, and I think we're going to see a lot more very quickly, and I think it's going to get worse. They don't start with the heaviest material. So we're going to see. Thank you all for joining us, and we look forward to seeing you in another 3 hours. Have a good night, all.